William Kennedy was a longtime employee at DuPont. He participated in their employer retirement plan, specifically the DuPont Savings and Investment Plan. Let's just call it SIP. Back in 1971, William married Leave Kennedy. So naturally, William named Leave as the sole beneficiary of the SIP, his retirement plan. I think almost everyone does it this way. They always list their spouse. Fast forward to 1994 and the couple divorced in a Texas court. Both of them had attorneys. The final decree was very clear. Leave waived any and all interest in William's retirement benefits, including the SIP account. She literally waived it. I'm done. That was William's account. Now, most people would assume that the matter was settled. She signed it away. The judge ordered it. The case is closed, right? Wrong. Because William never actually updated the beneficiary form on file with the SIP plan. Not after the split, not after he retired in 1998. He just left it there. In 2001, William Kennedy passed away. That SIP account had grown to over $400,000. And when the company looked at the paperwork, the name staring back at them was Leave Kennedy, the ex-wife. His daughter, Carrie, acting as the executrix of the estate, told DuPont to stop, do not issue it to Leave. Carrie pointed to the divorce waiver and said she'd waived any and all right to it. You need to pay the estate instead. But the plan administrator at DuPont didn't care about the divorce. They just looked at the form and they saw the designated beneficiary and they cut a check to the ex-wife, Leave, for the full $400,000. The estate fought back in court. In district court actually agreed with the family, but Leave appealed. Fifth Circuit flipped it. And eventually this whole mess landed in front of the U.S. Supreme Court. The highest court in the land issued a unanimous ruling against the estate. Justice Souter explained that under ERISA, administrators are legally bound to follow the plan documents, period. Not a side agreement with a divorce, not the obvious intent of the deceased, just the paperwork on file. And because William Kennedy didn't take 5 minutes to change a beneficiary form, his money went to the one person who had legally said, it's not mine, and agreed not to take it. But the paperwork won, and the family lost everything. The estate spent years going to a Supreme Court battle only to watch $400,000 walk out the door. So you spent good money on your estate plan. Maybe you have a will, you have a living trust, even better. You think everything's handled. Then you die. 5 assets that were sitting right there in your financial life, just like William Kennedy's retirement account, completely ignore your plan. They ignore your will. They ignore your trust. They don't care what you told your kids. They don't care what you wrote in a memo. They don't care if you spent $25,000 on an expensive estate plan or $2,500. They literally go wherever the beneficiary form, account contract, or title says they go. And if that paperwork is wrong, your money can go to the exact person you did not want receiving it. So today I'm going to show you the 5 assets that will commonly override your will, the disasters that happen when people ignore it, and exactly what you should do instead. Before we get into this list, I want you to answer something in the comments. Should an old beneficiary form be able to override a new will or trust? Should an old beneficiary form be able to override a new will or trust, something you put in writing that is after that beneficiary form? Put it down in the comments. What do you think? Give me your opinion. Feel free to correct others if their opinions are wrong. Because that is the fight that really destroys families. Somebody says, but Dad changed his estate plan. And the bank, the insurance company, or the retirement plan says that may be true, but this account goes by this form. So give me your honest answer. Should the most recent estate plan control, or should the account paperwork control until the owner changes it? Because right now, in a lot of situations, the paperwork wins. Let's start with the basic rule. Three categories you really have to understand. Category number one is probate assets. Category two is trust assets. Category three is non-probate transfers. If you do not understand the difference, your estate plan can look perfect on paper but still fail in real life. So let's start with number one, probate assets. These are assets that are owned in your individual name when you die and do not have a valid beneficiary designation. They don't have a joint owner or other automatic transfer mechanism. And this is what your will control. Your will is basically a set of instructions to the probate court. It says, here is who I want in charge, and here is where I want my probate assets to go. The key word here is probate. Your will does not control every asset you own. It controls the assets that actually go through probate. So if your house is in your individual name with no transfer on death deed, no survivorship owner, joint tenants with right of survivorship, no trust ownership, it's not in a land trust or living trust, that will likely be a probate asset. If your bank account is in your individual name and there's no paid on death beneficiary, that's going to be a probate asset. If your brokerage account is in your individual name with no transfer on death beneficiary, it's going to be a probate asset if it's in your name. Those are assets your will is designed to catch, and then you go to probate, you go to a judge, and you say, this is how we want it distributed. Category number two, this is trust assets. My personal favorite. Living trust does not magically control everything just because you sign the trust document. The trust controls what the trust owns. And this is why funding the trust actually matters. If your home is deeded into the trust, you don't need to probate it. It's not a probate asset. The trust controls it. If your brokerage account is titled in the name of the trust controls it. If your bank account is titled in the name of the trust controls it. The trust is kind of like a bucket. Only the assets you put in the bucket are controlled by the bucket, or think of it as rolling on luggage. You got to put your stuff in the rolling on luggage. The stuff that you did not put in the luggage, maybe it's sitting in your closet at home, that's not going to be controlled by the luggage. Now, a lot of people pay for the trust. Hey, they go and they sign the binder, they put it on a shelf, and they never actually move assets. They buy the luggage and they never put their clothing in it. They have a big bucket, but they never put anything in the bucket. Then they die, and the family finds out the trust exists, but the assets were never actually transferred into it. We see it all the time. And this is how you end up in a probate with a trust sitting right there staring at you thinking, we could avoid it, we could avoid it. Now, don't get me wrong, you can do a personal property assignment and fund the trust with like most of your stuff in a swoop. And there's always a pour over will that directs everything into the trust. Michael Jackson made this very famous. That's exactly how his estate worked. He didn't have everything titled in the trust, but it went through probate and the trust is the beneficiary. Now, while a living trust is a great start, the finish line is a funded living trust. That's an excellent plan. All right, so we talked about two categories, probate assets, trust assets. Now, category three is the one that surprises people. Non-probate transfers. These are contractual beneficiary designation transfers. Think retirement accounts, life insurance, paid on death, transferred on death accounts, jointly held property with survivorship rights. For these, it does not matter what your will says. It doesn't matter what your trust says. It doesn't even matter what your divorce decree says. That's what killed the Kennedy estate. These are assets that pass by contract, by beneficiary designation, by account registration, or by operation of law. Don't wait for probate. They don't ask the judge. They don't read your will. They don't care what your trust says. They follow the paperwork attached to that specific asset. The paper might be a beneficiary form, like in the Kennedy case. It might be a transferred on death designation. It might be a pay on death designation. It might be a life insurance contract with a beneficiary. It might be an annuity contract with a beneficiary. It might be survivorship language. Hey, we hold it joint tenants with right of survivorship on a deed. And that's the third category. And once you understand that category, the rest of this video will make sense. Because it's that category, that third category, that we got to watch for. And so here are the 5 assets that you really need to audit to make sure you don't get blindsided by this. Number 1. Retirement accounts. Your IRA, your 401k, your 403b, your TSP, your pension benefits. With these accounts, the beneficiary designation is usually the controlling document. Not your will, not your trust, not your paragraph in the trust that says, I leave everything to my kids. The form on file with the custodian or plan administrator, that's the boss. And this is where people get destroyed. They get divorced, they update their will, they update their trust afterwards, they change their house, they change their bank account, but they never update their 401k beneficiary form. Then they die, and the ex-spouse is still listed. Now, depending on the type of account and the law that governs it, that ex-spouse may or may not be paid. Like, there are things that may fix this in certain states, but federal law always overrides that, and it can be especially unforgiving here. Plan administrators follow plan documents. If it's an ERISA plan, that's the federal stuff. They follow that document rigidly. Do not assume that your will fix it, and do not assume that your trust fixes it. Take 5 minutes and go look at the form. I know it's a pain in your cartouche, but it's a lot better than giving somebody or someone that you did not intend to give a bunch of money. It's better than having them get a bunch of money and leave your family out in the cold. Number 2, life insurance. Insurance. Wow. Life insurance pays by contract. If you name your spouse gets it. If you name your kids get it. If you name your ex-spouse and you never change it, you're going to end up with a fight. Some states have laws that revoke beneficiary designations after divorce, but federal policies and ERISA-related claims, they can be very different. The Supreme Court has dealt with this in an issue. There was a Warren Hillman case where Warren had passed and had a life insurance form which he had filled out like decades prior, naming his ex-wife as the beneficiary. He got remarried. And his widow, of course, was not too happy that the ex-wife was getting the money. The state he lived in, Virginia, even had a law that removed the ex-wife after he remarried, but it didn't matter. Federal law controlled, and the insurance was paid to the ex-wife instead of his widow. Ouch. That is why I do not want you relying on a statute. I don't want to hear, my state says this. I don't care. Go to your plan. The better move is really simple. Change the form. Number 3, annuities. Same as above. Annuity is a contract. The contract names a beneficiary. When you die, the insurance company pays the beneficiary listed on the contract. Your will does not rewrite that contract after you die, and if you never named a beneficiary or the beneficiary is dead, the annuity may end up being paid out to your estate. Now you just created probate. The exact thing many people got the annuity to avoid. Look at the beneficiary form, make sure it's updated. If you need, put a contingent beneficiary, make it your trust. Number 4. I'm going to say payable on death accounts, and I'm also going to say transfer on death. There's basically different ways to say the same thing. So let's just say this is a bank account that has a paid on death designation. Something happens to you, it pays out to somebody else. A brokerage account has a transfer on death. Gets transferred to somebody. Here's the named individual if something happens to them. And people set these up quite casually. They're sitting at the bank and the banker says, do you want to put somebody on this account so it avoids probate? And they say, sure, put my daughter on there. Then 10 years goes by. They create a trust, they create a real plan, maybe they have more kids, and what they really wanted was all their kids to be treated equally. So let's just say they had 3 kids, they want them treated equally. But man, that old paid on death form is still sitting in the bank. And there was 1 daughter listed. So they die, the daughter gets the account, and the other kids get nothing from that account. And now everybody's pissed. And they fight. That's common. Way too common. Look at the form. It's not that hard. Cancel this, put it into the trust, put it into your plan. Much easier. Put it into your living trust directly. Put it in an LLC that's owned by your living trust. There's a million different ways to do this to avoid that issue. But it starts by, let's see how it's actually designated. Do I have this going on? What should I do about it? Number 5, joint assets. Jointly held property with like a right of survivorship. Maybe this is even if you own a property as a joint tenant with right of survivorship, the surviving owner usually gets the property automatically when you die. It doesn't matter what your will says, that, hey, half's supposed to go to my kids. Doesn't matter what your trust says, something else. The survivorship language controls. Joint tenants with right of survivorship. Somebody passes, it goes that. You might also have a transfer on death deed where if your state allows it, and you can record that deed, name the beneficiary, and when you die, the property transfers according to that deed. Now, that can be a great tool when used correctly, but it can also blow up your estate plan when you kind of use it casually. Right? We want to make sure that if you have a plan, that you're not absolutely getting tripped by one of these, that it's not flowing into your plan. So those are the 5, right? Retirement accounts, life insurance, annuities, paid on death and transfer on death accounts, and then joint assets. I'll just say joint properties, right of survivorship, and I'll even throw transfer on death deeds into that one for real estate. Now, set them all. Let's talk about some of the disasters that we've seen. We've already heard one, right? Ex-spouse. Let's just say Joe gets divorced, he updates his will, he updates his trust, Joe remarries. Joe has kids with his second spouse, but Joe never updates his 401k beneficiary form. Joe passes away, the plan looks at that form, that's an ERISA document if there's other employees. Old spouse is still there. Current spouse and the kids, well, they're shocked. But they say, but the will says we're supposed to get everything. Maybe there's a specific plan. Maybe there's a trust. And there's going to be an educational fund. There's going to be other things. The answer is, that's nice, but the account is not controlled by the will or the trust. Unfortunately, it's one of these. It's not a trust asset. It's not a probate asset. This is a brutal conversation, by the way. How about a second disaster? A minor child. You name an 8-year-old as a direct beneficiary on your life insurance. Hey, if anything happens to me, it's going to go to my kid. And you think you're being responsible, but a minor cannot legally control that money. Something happens to you. Now, the court may have to appoint someone to manage it, or maybe whoever that child's guardian, maybe it's an ex-spouse. Now they're in control of the money. There might be court supervision depending on the circumstances. There might be, whenever the court's involved, there's court rules and court costs, right? And then here's the part that I see. That child reaches 18. They're probably getting that money outright. Do you really want an 18-year-old receiving $500,000 or whatever it is because you didn't want to put it in a trust? You didn't want to use a plan correctly? You didn't want to actually do something responsible for them? That could change the trajectory of their life in a very negative way. And I know we think, oh, I'm giving a bunch of money away. I see money do more harm. Windfalls, statistically, increase bankruptcies. Statistically, you don't get to keep much of that money. It's less than 20%. They tend to do things with it when they're not prepared for it. So you took away the guardrails. Ugh. How about the accidental disinheritance? You got 3 kids. Trust says everything goes equally to the 3 kids. But your largest brokerage account, has one of those transfers on death, naming only one child because that child was the one that helped you set the account up. And you just said, hey, I'll just name that child in case anything happens to me. And you say, will you please take care of your siblings? Now, that child now gets the brokerage account directly. That trust divides only what is in the trust assets. Doesn't cover this. And you thought you were being equal, but the paperwork made it unequal. And now you end up, more than likely, that's going to be a lawsuit. So what do you do instead? Number 1, you run a beneficiary audit, not someday island, right? You do it right away, like do it this week. Just start getting your retirement accounts. Pull every retirement account, every life insurance policy, every annuity, every brokerage account. Just go through all this. Every bank with POD language, every deed. Look at who is actually named. Go through this. Just write this down, and I'm going to start pulling my accounts. Who's for the beneficiary? Who's named? Don't guess. Don't say, well, I'm pretty sure it's this. Pretty sure is how families end up in court. Step number 2. Name a primary beneficiary and a contingent beneficiary. A contingent beneficiary is your backup. If your first choice passes away before you, the money still has some place to go. With a backup, you can set up your living trust as the default. So if, like, hey, I have a spouse as the primary, you're still married, da-da-da-da, but if they predecease you, it's going into your estate. It avoids probate that way. And make sure that your wishes are carried out. Number 3, coordinate the beneficiary designations with your trust. You're creating an estate plan, please do. Make sure that you're being very thoughtful. This does not mean you name the trust on everything. It's like, do not hear that in what I'm saying. Your living trust should not necessarily own all of this stuff. But sometimes it should be a contingent beneficiary or a beneficiary. And that way, like, for example, that life insurance policy, if I had the trust as a beneficiary, then the protections in the trust, maybe I have my trustee, hey, it'll distribute money for health, education, maintenance, and support, HEM standard, so that if somebody has addictions or somebody has health issues or something, that it doesn't just dump a big pile of money on them. Maybe it's age. Hey, hold this until my kids are 40, 35, 40. Give them a quarter of the estate when they're 30, quarter of the estate when they're 40, but whatever. You can put all sorts of things in your living trust to put guardrails. Sometimes your spouse is going to be a beneficiary of these things. Sometimes maybe the kids could be direct beneficiaries. It depends on the amount and what it's for. On retirement accounts, you do need to be careful, by the way, because the Secure Act, I don't know if you heard about it, changed inherited retirement account rules. Most non-spouse beneficiaries now have to pay out on a retirement plan over a 10-year period. And so it's kind of forces some tax hit on them. If you name a trust incorrectly on some of this, you can actually create a bad tax result and bad distributions. Now, your spouse, for example, doesn't have that same rule. So maybe they're a direct beneficiary, and then if something happens to them, then you have the trust as a contingent beneficiary. So the answer isn't just put the trust everywhere. The answer is make the beneficiary form and the estate plan tell the same story, and make sure that we're considering the impact of what we do. Maybe it's my spouse, maybe it's somebody else, and then the estate plan is a contingent beneficiary. And that's the whole point. Your estate plan is not just some binder that you sign and stick it in there. It's not just a will, it's not just a trust. Your estate plan is a combination of your documents, your account titles, and your beneficiary designations, your deeds, and your contracts. If we have things that are in conflict, the wrong one may win. So here's your action item. Create an inventory. I call it an estate inventory. And by the way, I'm going to give you an e-version of the Anderson Emergency Binder. You can have it today for absolute free. This is what it looks like. But I have two asks. I'll give this to you absolutely free. Number one, is leave a comment in the comments. Tell me if you have stories to share, if you've seen any, these types of conflicts, tell your story. People need to hear it. Number 2, subscribe to my channel. And I'll say there's a third ask. Subscribe to my channel and share this video with somebody you believe needs to hear it. A lot of people, you know who they are. Just say, hey, take a listen. Now, download your emergency binder and start your inventory. The link is right there in the show notes. It's absolutely free. List every account you have, how it's titled, who the beneficiaries are, and if there's a contingent beneficiary, list that as well. And then compare that inventory to your trust and your will. If it doesn't match up, fix it while you're alive. Because after you're gone, they're stuck with the paperwork that you left behind. So if you do this inventory, you're like, oh man, if you don't fix it, they're stuck with it. And if you want help understanding how this fits into your estate plan, book a free consult with one of our advisors at Anderson Business Advisors. We'll walk you through your options and can help you build your plan. Start it with the emergency binder. That one is a no-brainer. It's absolutely free. You'll see it's a lot more than just an inventory. It is this is the kind of like the main document that people will grab if there's an emergency. Everything from who should I contact, doctors, dentists, and your pets, make sure things are handled, how to help my children, how to get into my accounts, how to get into my social media, things like that. All of that is contained in that emergency binder. And that way we don't have any more surprises. We look at our beneficiary designations, we look at our estate plan, we make sure they marry up, and voila, we actually have a very comprehensive plan where we don't have costly surprises. Now, I'll leave a couple of videos that will help you understand estate planning as well. Living trusts specifically, which I'm a big advocate of. And these are great primers and will empower you. So I'm going to leave those here, and I'll see you in the next one.